Hi, welcome to the award-winning Ed Brown Show. And once again, outstanding guests, if you're doing something, this is your opportunity to meet the delegate from Clinton, Maryland, Joe Vallario. He's chairman of Judiciary Committee. Also, he's been down there been in the chairmanship 24 years and has been down there 36. And that's why Prince George's County is so gorgeous, because we got delegates like Vallario. Vallario, welcome to the Ed Brown Show.
Thank you. It's 18 years as chairman
18
that I
years
have been the chairman of the Judiciary Committee. I think I'm the longest serving chairman that the state has ever had in record.
Okay, well, then there's some people here are not familiar with Joe Vallario. Give us your background. How did you get involved with this?
I've been a lawyer for 46 years.
Wow.
But when I first started practicing law, I decided I'd like to run for elected office. In 1970, I ran and lost, but in 75, I was fortunate enough to be with Senator Miller and Bill McCaffrey, who you know.
Right.
And we got elected then, and I've been elected. This is the 10th time I've been elected, so this is my 10th term that I'm getting ready to serve. If we win the general election in November, it'll be I'll be starting my 10th term as a delegate in the House of Delegates.
Right.
And I'm married and have 6 wonderful children and a wonderful wife who's just been absolutely 100% with me and behind me. Very fortunate.
You better give us her name.
Yeah, her name is Lisa Vallario, and without her, I'd be nothing. Believe me when I tell you.
What about them children and grandchildren? You got to give them a break too.
Yeah, you're right there.
Okay.
I have 6 children and 17 grandchildren and 2 more on the way this year.
Wow, still working.
And still working. That's exactly right. And so 3 of my children are lawyers, and the other 3 are married to lawyers and are nurses.
Wow.
Believe it or not.
So you have any trouble, you got the lawyers to take care of it, right?
Yeah. I need a few doctors to take care of me now.
Need some doctors. Okay. Well, tell us if we just finish up a session there, some of the things that the Judiciary Committee actually went through and presented to the state.
Yeah, we have most of our laws take effect October the 1st. So recently these laws have taken effect. In preparing to come over here to talk to you today, Ed, I went through and got a summary of some of the bills that we usually send out to most of the constituents to let them know what we're doing in Annapolis and keeping them up to date. And specifically, I thought I'd mention a few bills that really affect the individual constituencies that we have in the state of Maryland. The first one is that we have never had a homestead exemption in the bankruptcy statute, and today it's very important. And so we have like a $10,000 or $15,000 that they can't take your first $10,000 or $15,000 of whatever you might own, period. But in addition to that, we now have a $21,625 homestead exemption. And that number it follows the federal statute. So basically, if you have an equity in your home to the extent of $21,625, if you go bankrupt, they cannot take that equity that you might have in your home.
Is that right? That's wonderful.
You are able to keep your home to that extent. Now, if you got a $500,000 house, this is not going to help you, but this is a step in the right direction to help those people that are having real tough times now. And believe me, there are a lot of people out there that fit that particular category. They own a home, their equity is way down, but they have $20,000 worth of equity in there, and they don't want to lose that home. And if they do lose that home, they're going to have to go somewhere else. So we'd like to try to keep them in that home.
Right.
We'd like to protect their homestead. Some states have exemptions of their entire home. We don't have that, but we now have, for the first time, a $21,625.
Now, that $21,000, you have to have at least $21,000 equity in a home to keep it?
No. If you have, you could have up to that much money.
I see.
And you can
that would be the ceiling.
Right, that would be the ceiling.
Oh, I see.
So that is a big step in the right directions. All the lawyers that testified in the Judiciary Committee regarding bankruptcy statutes were very heavy on the idea that there were a lot of people out there that the one thing, they really didn't have a lot of debt, but they did want to try to make sure that they didn't lose their home. And if they have a maximum of $21,000 or less, they could at least keep the home, and they couldn't be
well, they can keep their home, but what about the future payments?
They're still going to be obligated on the payment, but they'll probably get some form of a payment plan that will help them keep that home.
Based on their income.
Right, and they won't, of course, lose, the holder of the mortgage won't lose their interest. The mortgage will still be with the property, but at least there'll be some comfort level that they can't lose their home. They can't be booted out of their home if they have $21,000 worth, up to $21,000. The next thing that we did this year was this. We passed a bill that said some of these insurance companies have gotten around and said if you have an automobile accident, we have what you call personal injury protection, which carries up to $2,500 of bills, which pays your wages. It also pays your wages and minor medical bills, or medical bills up to $2,500. And what
regardless of who's responsible.
Regardless of who's responsible, it's personal injury protection. No matter who's responsible, there's $2,500 worth of medical payments or loss of wages. What the insurance company started to do, saying, hey, well, look, before we're going to start paying out of our hospitalization policy, you got to use that $2,500 up.
From the state. This is state money.
No, it's not state money. It's money in the policy. It's in the policy. And what happens was the hospitalization people were trying to take advantage of that $2,500. And what we said, that's not possible. That's a separate policy, that the people pay their automobile policy. It says, look, I'm covered up to $2,500, and that will continue, and that your hospitalization is not going to be able to take advantage of that. I guess the big bill, one of the biggest bills that we passed this year was this. We raised the minimum amount of insurance. You know, everybody's had to have $20,000 worth of insurance. Everybody is covered up to $20,000. That was the bottom line. That's been since 1978.
Okay.
And this year we changed it. It's no longer 20/40. It's 30/60. So every policy has got to have a minimum coverage of at least $30,000 and $60,000 total for the whole if there are more than one person involved in an injury. So the liability insurance has increased, liability now, from 20/40 to 30/60. So
this is regardless of the fault.
Well, that's for fault. If you're at fault, you're covered up to a minimum of $30,000. Your policy, if you had the minimum policy, would have to be at least $30,000.
Oh.
And the guy that hits you, the minimum he can have is 30/60. He's got to have a minimum of 30/60, which is extremely important. With respect to protective orders, a judge can extend up to 2 years of protective orders if you or violate a protective order, which means you've been booted out, you're not to have contact with the person, or something. You violate that order, the judge can add an additional 2 years of protection for the victim. Right now, the maximum amount that a judge can order is 1 year, and generally they order a 1 year stay away or 1 year to leave the person alone. But now they're going to be able to extend it for an additional 2 years if the person violates that protective order. If they violate it by going around or do something that's in violation of that protective order. Yeah.
Right.
The next one is there's been what we call a shield law. Unfortunately, if someone takes out a protective order in today's day and age, believe it or not, only 50% of those cases ever become final orders. And either the parties reconcile, or there's no order, or they can't prove by clear and convincing evidence that they're entitled to an order. So we're only talking about half of them that ever come to a final order, because you get your initial order by going to the commissioner or to the judge, and then 7 days later is when the final order. A lot of people don't show up at the final order.
Well, tell me this.
And they're dismissed.
Okay, they're dismissed, but what about individual that doesn't have the money for an attorney?
It's not a criminal, it's a civil aspect, and they can't go to jail unless they violate the order.
That's what I mean.
Yeah, that's the only time that they can go to jail is if they violate. If they violate the order, then they're entitled to an attorney. But the initial order.
But attorney is paid.
Yeah.
Okay.
Well, it could be the public defender. It
Yeah,
can be the
well, that's what I
public
mean. But
defender.
they do have an attorney. Right.
Yeah, but the purpose of this law was that it that the shield law was that when they don't go to court, they don't show up, it's still on the books. The parties reconcile. There's never been a finding that the person did something wrong. And they still have, 5 years later, they still have a record, hey, there was a protective order against you by a person. We tried to erase that. So now what we have is a shield where it still stays on the books, but it's not open to public. You can't just go on your computer and find out this person had a protective order. And the purpose of that is so that, one, the police are aware that there's a protective order, one, and two, the person's not subject to, for the rest of the remainder of their life, just because someone filed one of those protective orders, have that on their record, even though there's never been a finding. Never been a finding.
Never been.
And yet
no
they still have,
decision's been made.
Right, and yet they can't get it expunged. And that's a bad, bad thing, we thought. This year also,
does that hinder a person from
getting employment? Getting employment.
That's what I was thinking.
I mean, nobody's going to hire a person who's had a protective order against them, or had an initial protective order, no final order. It's still not. So why take a chance on that person?
But that becomes, protective order becomes part of the record for life.
And now it's going to be able to be shielded so that it's not open to the public.
Oh, I see.
And that's the only purpose, so it's not open to the public that could affect somebody's employment. Now, if the order is granted, then it will always be a record of it. But it's only those cases where there was never a final order that was ever issued that the person could have it shielded.
The person that filed can actually not continue with the case.
Yeah, I mean, if they don't show up and it gets thrown out.
It's thrown out if they don't show up.
If they don't show up, and that shouldn't affect that other person for the rest of their life just because they took it out. Also, in Prince George's County and Washington County, we're going to have a situation where the judge can order a GPS, global positioning, on a person an order is placed against. We don't see that happening every day. What's
the GPS now?
No, where they put a bracelet on your leg, and then they know every place you went. So if you went down there by the house, they're going to be able to pick you up. They're going to say, hey, what were you doing around that house? You know you're not supposed to be over there. They're going to be able to find out where you're at all times. So that is important. Now, last year, the year before, we try to pass bills sometimes that don't cost a lot of money. And one of the things that we passed was this, that when the party is served with that protective order, the sheriff now is going to pick up the phone or text somebody, hey, look, your husband or your boyfriend or your girlfriend has now been served. We want to let you know that up front so that the person is aware that the other party has been served. And that doesn't cost any money to let somebody know that the person against whom you filed a complaint has now been served, and you should at least be aware of that. Child support guidelines went up this year.
That's a big one.
That is a big one. And they haven't been changed since the 70s, 1970s. And although income is going up, and I thought, well, income's going up, support's going up, we revised the child support guidelines this past year to be more in line with what the rest of the states are. It doesn't affect current orders, but it does affect future orders.
Oh, there's future effective October 1st?
1st, yeah.
Yeah, okay.
No, that one really takes effect January 1st.
January
and it will affect just future earnings only. Sex offenders. Sex offenders was probably the hottest item this year in the Judiciary Committee. That was a big item.
Right?
We had, and it came about because that girl that got raped and killed on the Eastern Shore.
Right.
And they were out there looking for that child on Christmas Day, if you remember. And that was a big, big move, and it really strummed a lot of interest in the sex offender registration. Now we're going to have lifetime supervision, and as I indicated, there's some things that don't cost a whole lot. If somebody is a sex offender, and they got to register every 6 months or every 3 months,